organizing this wonderful conference and for their hospitality. They've taken excellent care of all of us. I thought I'd start by, and I want to apologize, I'm not used to using PowerPoint. In the United States, I have a classroom covered with blackboards, and I write with chalk. And my prior attempt at using PowerPoint was a disaster, but I'll try to do better. It's not really PowerPoint, it's a Word document projected. The U.S. tax statute is extraordinarily wordy, and the English word is prolix. The statute covers about 4,000 pages of text, and then interpretive regulations run another 12,000 pages. And although I was showing off at lunch, I have an app for my iPhone, and the entire 16,000 pages are on my iPhone. I don't even have to go to the internet. Notwithstanding that, it's an enormous amount of material, and most of the tax statute is very, very specific, prescribing what happens exactly in concrete circumstances. But since at least 1935, when there was a U.S. Supreme Court decision in a case called Gregory v. Elvering, it's been the rule that compliance with detailed requirements of the statute and the regulations will not necessarily provide the tax treatment that a taxpayer seeks. And in Gregory, a taxpayer meticulously designed a transaction to comply with detailed statutory requirements for tax-free treatment. And despite that, the Court of Appeals and then the U.S. Supreme Court denied the tax-free treatment that was sought on the grounds that the transaction involved tax avoidance. And so ever since, whenever American tax lawyers advise on a transaction or design a transaction, they have to ask themselves, is there the kind of tax avoidance inherent or implicit in what we've done that may lead to denial of what we seek? Now, sometimes a lot of countries I know have statutory general anti-avoidance rules. We really have not had a general anti-avoidance statutory rule in the United States. The general anti-avoidance principles are ones formulated by courts. And I thought it would be interesting, these anti-avoidance rules or substance over form rules are applied in lots of different circumstances. And I thought one way to illustrate what American courts do would be to take a narrow subject matter area, the idea of realization, that a gain or loss on property only gets reported when there's a sale or exchange, a realization event, which is something that's common to almost every income tax system, and look at how U.S. courts have applied, particularly the Supreme Court, tax avoidance substance over form principles. Now, I've done something, I think, here we go. And I just wanted to give you one. I think this is on the board. There's a leading treatise on U.S. tax law, and it has a sentence I always read to my students because it is so chilling. And it is the Gregory decision saying that literal compliance with the statute and the regulations is not necessarily enough, has penetrated every crevice of the tax law. It's a pretty extreme statement, and must always be in the forefront of every tax lawyer's mind. So that's a pretty strong general anti-avoidance principle that's in U.S. law. Now, let's see if I'm getting here. So the first case I thought I'd talk to you about is an old U.S. Supreme Court case, actually decided 5 years after Gregory, called Higgins v. Smith. And the facts are pretty simple. The taxpayer, who's a Mr. Smith, owned property that had fallen in value, and he wanted to deduct the losses on the property, but he wanted to continue to hold on to the property. So what he did was to sell the property to a corporation, a closely held corporation of which he was the sole shareholder. And the sale in this case was not a sham. It was what we call a bona fide sale. Legal title to the property was transferred to the corporation, and the corporation was the legal owner. And for most other purposes of the tax law, the corporation and its shareholder were treated as separate persons. The corporation was taxed on its income, and Mr. Smith was taxed on his separately, even though he, in a real sense, the corporation was really his alter ego, something that he owned completely. But the Supreme Court held that the sale of property to a wholly owned corporation is not a real realization, or a realization in substance, and deduction of the loss was denied. And actually, for later years, this principle that sale of property at a loss to a related party was codified, and there's now a section codified of the U.S. tax law that specifically denies the deduction of losses on the sale of property to a related party. The idea being that there is no realization in substance, but that statute did not apply to this case. It was not yet in effect. Okay. If you want to interrupt me with any questions, please do so.
But there could be a change in the substance, couldn't there? Because creditors of the company might then be able to access the assets of the company.
That's right. I mean, you could argue that something has changed, right? But in the circumstances, on balance, the deduction was felt. What the court said was that, in effect, he still has command, control, and use of the property. Okay, and in fact, the statute that was enacted after Higgins v. Smith was decided goes much further. For example, in some ways, it's an easy case because the seller owned all of the buyer corporation. Under the statute, if you sell property to a corporation and own 50.1% of the stock, a loss deduction is denied, even though arguably there's been much more of a change in circumstances. Although I think that's a result a court would be unlikely to reach. That's reached as a result of a statutory enactment, which is different. And I'm restricting this presentation, trying to restrict it to what courts feel free to do.
And what do you mean with related parties in the U.S.? You mean there must be a relationship of control, or be the sole shareholder, or to...
Well, the statute is very, very specific. There was no statute that applied in Higgins v. Smith because it had not yet been enacted. Okay, but I think, let me see here, the statute actually is very, very detailed, and for example, if you sell property to your spouse, your siblings, your ancestors, grandfather, great-grandfather, great-great-grandfather, or any of your descendants, great-grandchildren, the statute says any loss is not deductible. And the same is true if it's a corporation, or sale to a corporation or a partnership in which you have more than a 50% interest. Okay, so the statutory rules go quite far. But this, Higgins v. Smith is a judicial decision in the absence, pre-enactment or pre-application of the statutory rule. Now, the second important judicial decision in this area, which was actually not a Supreme Court decision, but from the tax court, which is a lowly trial court that specializes in tax matters, but it's and the decision was never appealed, but it still is a very important precedent. Horn, and there, the taxpayer owned a what we call a seat on an exchange, which people sold tea, coffee, and sugar. He had bought the seat for $24,000 with terrible timing. He bought it in 1929 in July, and in August the value of the seat plummeted and remained low. And then 12 years later he bought a second seat on the exchange for $1,000 in 1941, and then 10 days after buying the second identical seat, he sold the first seat and claimed he had he could deduct the loss, which was $23,000. And one thing to notice about this is that the Higgins v. Smith principle cannot apply here because the property is not sold to a related party. It's sold to some unrelated third-party stranger. So the idea that there's no sale in substance because you still in effect control the property through an intermediary cannot apply. Here the idea was that the thing is sold, but the replacement is identical. And because you've sold property and replaced it with identical property, the loss should not be deductible. And that was it's not a sale in substance. And again, this was a judge-made rule, a court-made rule, and there was no statutory provision that applied. And this kind of sale, in English the expression is wash sale. I don't know if in Italian, what would you say, Marco?
To translate wash sales in Italian, I don't know, but we probably have a similar problem with the sale and leaseback operation. When you sell one of your assets and you get it back
through a long-term lease. Yeah, that's sort of a wash. It's a wash. It's a wash. And at the time this transaction occurred in the U.S. Code, there was a wash, what we call a wash sale provision, disallowing a loss if you sold property and within 30 days acquired identical property, but it applied only to stocks and securities. And this seat on the exchange was not a stock or security. So again, you had a transaction that was not reached by the detailed provisions of the statute and the regulations, but what was felt to be abusive. And then the third case that I thought would be, there are really just two other cases, and then I'll, now what's happened here?
Can you do page down?
Sorry?
Page down or
Oh, here we go. I found the right.
the wheel.
The wheel is what I have to do. This is a favorite case of mine, McWilliams. Again, the same issue is a loss on property deductible. So Mr. McWilliams owned stock, publicly traded stock, and it had fallen in value. And he wanted to deduct the loss, but he wanted to hold on to the stock. He felt it was still a good investment. And he was married. And this was before he was a chauvinist, and So what he did was he sold his stock and simultaneously caused his wife to buy identical stock. So that, for example, he sold 100 shares of General Electric stock, and then simultaneously his wife purchased 100 shares of General Electric stock. And the Internal Revenue Service, again, you seem to be in a place where there was a statutory gap, because his stock was not sold to a related party. It was just sold on a public stock exchange to a stranger. If it had been sold to his wife, the loss would have been denied because it would have been a sale of property at a loss between related parties. And so that the Higgins v. Smith principle couldn't apply, and nor could the wash sale principle, because he didn't buy the stock and buy back identical stock. He bought the stock, and it was his wife who bought back identical stock. Okay. So you had a kind of gap that fell. It combined elements of both a related party sale and a wash sale, but it was in between what the statute covered. And to make things even more difficult, this was at a period of time at which taxpayers in the U.S. still filed individually. There were no joint returns. If there had been joint returns, you might have said, well, he and his wife are in effect one taxpayer, and one taxpayer has sold stock and then purchased identical stock. But that kind of argument would have been hard to make. Nevertheless, the U.S. Supreme Court said they couldn't deduct the loss. It felt the transaction was abusive, and the loss was disallowed. So these three cases, Higgins v. Smith, Horn, and McWilliams, are, I think, nice illustrations of American courts looking beyond the specific language of the statute and denying deduction of a loss in a fairly limited, confined area where they think there's an abuse. Now, the fourth case, and then also I don't want to go on too long, which is more recent, is a case called Cottage Savings. And in Cottage Savings, there is again, a taxpayer who has a loss on property tries to deduct the loss and is challenged by the Internal Revenue Service on substance over form grounds. And this time the taxpayer wins. The IRS loses. So I think it's interesting to look at Cottage Savings and try to figure out, well, what's different about it? And basically what happened was Cottage Savings is a bank, and this is reminiscent of recent events. It gave home mortgages, although it occurred in the late 1970s. It was a precursor to our current situation. And it extended home mortgage loans. The home mortgage loans had decreased in value as interest rates rose. And so Cottage Savings took what we call a pool, a collection of these home mortgage loans, and exchanged its portfolio of home mortgage loans, which had decreased in value, for another portfolio of different home mortgage loans. And what was critical here is that, let me scroll down a little, the loan portfolio transferred and the loan portfolio received had virtually identical economic characteristics. All the loans involved what we call single-family residences. They had the same terms to maturity, the same interest rates, the same initial terms to maturity, the same remaining terms to maturity, the same loan-to-value ratios, and so on. So that you had one group of securities exchanged for another group of securities, and the pertinent economic characteristics, the expected return, the risk, and the category of security were all identical. Nevertheless, the Supreme Court and the IRS argued this is not a real it's not a real realization, it's not a realization in substance, therefore the loss should not be deductible. And the Supreme Court disagreed, and basically what it said was that and notice here, if you're going to disallow the loss, it can't be done on the idea, the Higgins v. Smith idea, that the property is held by a related party, therefore it's still within the dominion or control of the taxpayer. It has to be based on the wash sale idea, that what you've sold or transferred is replaced by something that's identical. And the U.S. Supreme Court said, despite the identical economic characteristics, the thing transferred and the replacement are different, sufficiently different, because they are literally different loans secured by different homes and with different debtors who are obligated on the loans. And that's enough of a difference for us to say a kind of wash. It isn't a wash. In order for it to be a wash, the things transferred and the things received must really be truly identical. And simply having the same basic expected return and risk characteristics is not enough. Okay, now John, I think I've gone on. I've done 20 minutes, so exactly right. Okay, that comes from 30 years of classroom teaching with a clock hidden. So I'll stop unless there are any quick questions anyone would like to ask. Yeah.
Okay, we better make fairly quick questions because we'll have most of the questions on the totality, but go ahead.
That was just an observation, really, that, I mean, it seems to me that the Supreme Court got it right here, and that it seems extraordinarily extreme to disallow a loss which is a true economic loss, and it is.
It is, yeah.
I mean, forget that you're right about the controlled one, but the wash transaction is a true economic loss that's been, and that this later case sort of demonstrates probably the right way of thinking. I mean, it's common, isn't it? In the UK, for instance, being reckless transactions on capital. They do that, or the UK permit that as an absolute practice to recognise a sale and repurchase and corresponding
And allow the loss.
Absolutely.
Yeah.
Well, shall we thank Stephen and then I'll move to Thomas and then we'll have comments afterwards. Thanks so much, Stephen. Thank you.